A very good evening to our viewers. Thank you for joining us tonight on the Evening Review. My name is Toiban Jabela, your host. Tonight we are welcoming back to the platform Professor Job Amupanda, who this week filed a complaint with the Judicial Service Commission against Judge Shafimana Ueitele, who is presiding over his case around the issue of the red line. Professor is here to help us unpack what his complaint is about. Thank you very much, Job, for making time. Very early in the year, big noises already about so many issues. I don't want to venture very much into your case because it's still before court, but the complaint, I think we can discuss that. What are you complaining about as far as Judge Ueitele's conduct is concerned?
So, as I said already, when the Constitution was drafted, we have all these branches of the state, the judiciary, the legislature, and then the executive. Those are distinct branches of the state. They're not one and the same. The executive constitute that central government. Unless you are Kenneth Matengwe, Vice Chancellor of UNAM, who believes that Parliament is part of central government. He actually says these things in writing. But we understand these institutions are separate and they serve a particular purpose, each one of them. The purpose of the judiciary is to obviously interpret the law and also deal with issues of dispute that people are facing. And unfortunately, what has happened in our country is that we haven't really focused primarily on the judiciary from various perspectives. There's this impression because when we go to court, you go there, and when the judge walks in there, we all of us stand up and they address as my Lord, my God, my worship, and things like that. And part of the problem is that we don't actually take time to understand that these institutions of state, this judiciary is supposed to function in the interest of the people of Namibia, not in the interest of judicial officers. But those people who crafted our constitution understood that there would be judicial officers. By judicial officers, I mean judges, for instance. There would be judicial officers such as Ueitele, and if Job becomes a judge or any other who are going to behave in this manner. So they had an imagination that it is possible to have a judge who behave differently. It is possible to have a judge who somehow park the rules of engagement and start implementing something else. When that happens, there must be a remedy. And that remedy is provided for starting with the Constitution and then the legislative instrument, which is the Judicial Service Commission Act 18 of 1995, and the subsequent regulations that were developed. So it particularly says to you that, look, if you are not happy with the judgment, you go to the Supreme Court and appeal. The Supreme Court, you can be heard by 3 judges because they understood that human beings can make mistakes. Yeah, so you have that remedy. If you're not happy with the judgment, you can go to the Supreme Court. Yeah. But there will be time where the Supreme Court would not, for instance, be able to remedy the conduct of a judge that has nothing to do with matters of law. That's why there is these provisions, Section 4 of the Judicial Service Act, that deals with the conduct of the judicial officers. So the primary focus of the complaint is the conduct of the judicial officers. The fortunate thing is that it's not difficult for me, is because the judge himself, the beginning of trial, before the beginning of trial, both the judge and the Supreme Court, the High Court and the Supreme Court have already found that this is a case of public interest. So any argument that this is job, this is what, this is politics, it's that position, you are defining yourself outside the instrument itself, including the judge himself. He have already made that determination, and that determination has been confirmed by the Supreme Court that this is a case of public interest. And because it's a case of public interest, we saw that the media was allowed to broadcast these events live. So whatever it is that I'm ventilating and I'm saying about what has happened, it is not just my own imagination. It's something that is out there in the public. Everyone would be able to confirm and see what has been the concern. In fact, I have realized, shockingly though, that people out there are more angry and more angrier than myself, given what has happened in court. They're asking me questions. Yeah, what did it happen? Are you guys? Did you have any business or a CC together with a judge, or does your lawyer have? Maybe they cross paths. What is basically going on? And they're asking. Sometimes I can't answer those questions, but the basis, firstly, I'm answering your question to say that it is provided for in our law that when the judge is offside, there's a remedy for that. There must be a remedy for that. And the basis of a complaint must be gross misconduct. It will be mental incapacity. So the section speaks about what is it that you need to be able to meet, what is it that you need to be able to do. Yeah. So you have to do it on affidavit and then submit it to the Supreme Court. Now, the legal practitioners represents litigant. If it was not required that you must have lawyers representing you, I would have gone and represented myself. So Advocate Tinda or Mr. Kadila Momo is not representing themselves. So when I'm sitting there in court and the judicial officer makes my case and the case of Namibian people whom the court have identified that is a matter of public interest, and you are making it about yourself, like, how did I teach you? Oh, I failed to teach you properly at school. It has nothing to do with what you guys used to do in your classes, what you failed to do, what you think your learner didn't do that. It's about my case. That person is representing me.
Yeah.
So my legal practitioner throughout the trial couldn't even get an opportunity to ventilate the issues.
Yeah.
The other legal practitioner stands up. They just throw whatever it is that they throw. When my legal practitioners respond, it becomes an issue, and you could just see clearly that there was a big problem. So the first primary argument is that my legal practitioners were hamstrung, my legal practitioners were decapacitated, and they were prevented from advancing my case. Those videos are there. You can easily see that this guy from South Africa who's representing the other guys and the Namibia Agricultural Union, not a single interjection. He finished, he presented, and he finished. Then the Heathcote representing Midboard, he presented and he finished. In fact, he was even said before he started arguing and said, no, don't stop me, my lord. And then the judge just smiled. Okay? So the first point is that my legal practitioner could not even got an opportunity to do that. In fact, before he could even stand up, the judge says, no, I want to present an article. So we were all wondering, okay, it's very interesting. Maybe the article is going to be important for the future. And just for us to come back, and he's using that article, that on that article he says the red line was established in 1961. We have never had, because you as a litigant, you must present evidence, and the other team must also present the evidence, not the judge presenting the evidence to himself and arguing on that.
He's the one who did that.
He's the one who, the video is available, and in fact in that complaint we also share that video. We share that the actual video. We submitted a USB also, so that the members of the Judicial Service Commission can actually see, not just the claim that is on the affidavit, they can actually see that he's the one who saying this is an article. Now, I mean, there are 10 or 20,000 articles, journal articles that are written by Namibians. Professor Hans Amkugo, for example, is one of the top academics at the University of Namibia. He has just one, maybe close to 100 academic articles. So, but he chose one. A judge chose a particular article by particular individuals whose relationship to whoever we don't know, and he presented it as evidence. That is a serious misconduct.
I hear that. So is your complaint to the Judicial Service Commission about those behaviors in court, or is it because you also raised very important, a very big issue this week about Judge Ueitele having been exempted from paying land tax by the Minister of Agriculture, Kalesh Lightfine, who is the first respondent in your case. Is it a combination of both situations, or is it primarily how he was behaving from your perspective?
Yes, definitely we will come to that, because that now is a matter of public record, and the public is busy engaging that story. So we don't know whether this is a resettlement farm or it's not a resettlement farm. These farms are two. One is 4,000 hectares, one is 1,700. We don't know whether those guys are exporting to Europe, which is the theme of debate in court. Let's come there. Let's park that issue there. Now, every Namibian is equal before the law. But the judge says, Mr. Amupanda is a declared politician. I was sitting there wondering, what is going on here? Mr. Amupanda is a declared politician. He has taken sides. You cannot bring him to court. He peddles, these are his words, né? He peddles a particular line. I don't know whether it's a red line but these are the words of the judge. But I mean, how do I go to court and have a general position to say, I don't know what's happening, whether I'm for or against? Obviously, I go to court to speak on a particular position, but he says to us that no, politicians cannot come to court and vindicate the rights. The same politicians that are given rights by Article 17 of the Namibian Constitution. He says Mr. Amupanda is a declared politician. He doesn't say declared by who. We don't have politicians declared. That's not how we understand politicians being declared. But these are the things that he says. Then when you sit back and you realize, oh, okay, this is something else. Definitely. So that is a problem, because that basically means it's discrimination on the basis of my political views. He's saying my evidence must be treated in a particular way because I'm a politician. Yeah, it's a problem. That conduct cannot stand. It brings the judiciary in disrepute. This judge says to my legal representative that no, if I ask you, but remember this case was broadcasted live. The family, the mother of my legal practitioner, my mother, and everybody else is watching. The judge says, you don't know for sure whether your father is your father. Now, can you just imagine, say it in our language? Somebody just saying it, this is what the judge says on TV. So, when you leave court and the judge says that, then you go home and you look at your father, what's going to be happening? And this is not just you, it's everybody else, because apparently no one knows that their parents are their parents. No one expects that to come to court and you are going to be told about the bedroom affairs, because he says, you don't know for sure that your father is your father. And why is it that you don't know? Because you were not there when you were being made. You were not there when you've been born. So what are you talking? You are talking about bedroom affairs of that. We can't have a judge who says that they are young, there were young students there who were watching and were following. And if they think, oh, if I go to court, my parents will be mentioned. And then he says, which class did you attend at UNAM? I mean, my advocate has children. He's a headman at his village there, and he's a distinguishable gentleman, very peaceful, very calm, even in that storm. He's a respectable, a reputable person, one of the most smartest people that I know. And for him to be humiliated like that, to an extent, then the judge goes and say, it's one thing for me just to complain, or any other person to complain and complain. Yeah. But here we are dealing with a person who has committed a crime, and he agrees that he has committed the crime, and he went to apologize for the crime.
Yeah.
It's on record that the judge is saying, no, I want to apologize. But remember what I said at the beginning, that the legal practitioner is not representing himself, he's representing me.
Yeah.
Now you do that to my legal practitioner. Then as a result of what you do, which you recognize that is wrong, my legal practitioner was unable to advance my case.
Yeah.
You convict yourself, you find a remedy which is an apology. And then I must just sit here. It's not his case, it's my case.
I hear you. So let me put this to you. One of the things that Judge Ueitele said quite repeatedly during this process is that you and your legal team were ill-prepared. You came ill-prepared, you didn't present any evidence, you didn't say which rights specifically of people are being trampled upon by the presence of this tool called the red line.
That is actually very scandalous. And he said that, but the lawyer that is representing the South African guy who was representing the millionaires guys and the Namibia Agricultural Union, he came to indicate that my right to dignity was pleaded. And he says that no, that he's saying his defense is that no, there was the article right to dignity that was pleaded, but the pleading doesn't meet the threshold. What does it mean? And he gave an example of a case in Europe. Apparently in Europe, people had to resort to drink water from the toilet. So your rights can be violated according to this logic. Your right can be violated, but to step on the mat, to get out of the car for your meat to be convicted is not so bad compared to people in Europe who had to drink from the toilets. So there's a major and material contradiction between what the judge was saying. I mean, if there's anybody who was unprepared, is a judge himself. You see, the rule says that before the trial begins, the managing judge must issue a pre-trial order. We never had a pre-trial order. The pre-trial order was issued on the same day that the trial began.
Yeah.
So the idea that we were not prepared, and you could see it was a point that was made by, and people started uncritically accepting this thing that we're not prepared. So we pleaded Article 8, we pleaded Article 10 in terms of the rights that are there. So they can't fault, and you could see that we are saying to court even that this instrument was not established in terms of any law.
Yeah.
Now, instead of the other people to come and say it was established because of ABC, the judge goes and say, no, you can't find any law. Does the court has hands and arms? So you could almost see that the judge was behaving as if he's a ninth defendant in the matter. So look, we were prepared. We advanced our case very well. We even issued subpoenas in terms of our witnesses to come. Yeah. We even discovered documents that are discovered, in other words, they are already before court record, and he refused to accept them, but he agreed to accept the other documents. So those are all issues that we are talking about in terms of that specific complaint. Like, for example, when a man says, tell Amupanda, it's not the first and last time he's going to come to court. What does that mean? So meaning next time when I come there, I will not get justice? Or when he says he's a declared politician, his evidence must be treated. I have 2 boys, so if my boys are something happens to them at school and I go to court, they're just going to say, oh, these are the children of the politician. Yeah. So it doesn't...
I get that.
It's materially very problematic. But now, even with the new revelation of the text...
Yeah, because that is where I want, because we don't have enough time now. Yeah. So I want to touch on that quickly. So what I find troubling personally, and my views on the red line are known. I don't go around hiding that I'm in support of it. I'm totally against it. I'm very open about it. But when you summoned Saki Shangala to come and testify, he said, credit to that man. He said, I farm in Leonardville, in Omaheke region, and therefore I will not be an objective witness. Maybe, of course, maybe he was supposed to testify on other things, but he said he used that as logic. We at Namibian Sun called, when we were speaking to some of the public figures to express their views on this issue, we called Nahas Angula and we said, what is your view? Because we know him as a straight talker. And he said to us, I am conflicted on this matter because I am a farmer south of the red line and I also have animals north of the red line, and therefore I'm conflicted. I cannot really give you an objective response. The judge, we are told that according to the papers that you released this week, that he owns farms south of the red line. When the likes of Shangala saying, look, I must stay away from this case because I'm conflicted. When Nahas says I'm conflicted, I can't comment. The judge, who is a farmer and has interest in how this matter is resolved in the end, doesn't declare that interest.
It is a very problematic thing, because that's why when we saw that, it was also a shocker to us. Because remember, we had asked for a recusal, but we asked for a recusal intimating some of those concerns of conflict, but also in a manner in which how he was expressing himself in chambers, but he made it very difficult for us to bring that application. It is very, 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 very problematic, and this is what we must seriously problematize in our country. Those people, Nahas or Shangala and them, no one is asking them to recuse themselves. They are saying it by themselves. So the first question that the judiciary and everybody else must ask, on what basis, without anybody requesting you to recuse yourself, on what basis do you continue to preside over that case, knowing what you know? Because he knows the biases. Because this is what we must be able to. There is an application that can be brought by a litigant to say, I'm not comfortable. I don't think there's a reasonable apprehension of bias. I don't think you can objectively be able to deal with this matter in this way. So before we even get there, and this is what Namibians must, this is what we expect of our judiciary. These are standards that we expect of the judiciary. For a judicial officer or whoever it is that is assigning him to the task to know. It's one thing for you to have a small farm, small,
subsistence.
Yes, little 5 goats. But this is a commercial farmer with not one farm, with 2 farms. At least those are the ones that we saw in government documents. So it's no longer in doubt. His name is identified positively, the farm size is identified, and the size, and the minister who actually, because the minister has discretion. People thinking that, you are allowed to do exemption and things like that. That's not the concern. Here is a minister who has discretion. What does it mean? It means you have a decision to say yes or no. Here is a judge who applies for it. Okay? And then is granted. So, the minister exercises discretion to the benefit of a judge who is presiding over a case that relates to those things. And that's why you will see that, there's no evidence, go and exhume. This is a judge who says, go and exhume. What if we go here with my legal practitioner? What if we go to those graves of those guys, anyone that has, because the court, because remember we are talking about the country as a rule of law. The court is the one who gives orders, and those orders must be implemented. We have been ordered to exhume. So what if we get graders and we start digging those colonizers? Because he says we must dig them and bring them to court. So what if we start digging and bring those bones there? Because the court have said so. And the court never said it's a joke. Because my lawyer, when he heard the judge saying, go and exhume those people to come and testify, my lawyer said, I'm going to ask Jesus to help me. No, you are making a joke out of it. No, but my lawyer was saying he's going to pray to Jesus so that people can resurrect. The Bible says you can resurrect. Come back on earth, and then you can come and testify. So it is the point I'm trying to make is that the recusal, objectivity and integrity of a judiciary, the onus is not just on a litigant. It's first and primarily on a judicial officer who get allocated a matter. It's primarily on those that are allocating this function to this specific person. And it's not vice versa. And the people of Namibia must know, because if that's what we expect, it basically means then that all these corruption things that are happening in our country, unless somebody objects to it, it's okay. That's not the type of society that we want to live. It's that we are very happy that people of Namibia saw what had happened in court. They can equally see the documents. I didn't establish it with I heard yesterday that one of the members of parliament asked a question to the Minister of Agriculture, Karl Schlettwein, and said, but it's provided for by the rules of parliament, and asking, how did this happen? What was the motivation did the judge give? And I would have hoped that he would have asked whether it's a resettlement farm or not, and how was he resettled and when. Karl Schlettwein apparently waited outside. We are waiting for the version of the MP, and he said to him, fuck you, what are you trying to imply? So you can see that there is some sort of impunity, people can do whatever it is. A minister, when he's asked for accountability for his action, because why would you do that?
Yeah.
Why would you do that? So the point that we must make here, it is important that the onus is on a judicial officer such as Justice Ueitele, The onus is on even the minister who's exercising that power. I'm an ordinary citizen. I'm a litigant who's coming to court. Yes, we did ask for a recusal. We didn't want it to proceed in this manner. We are complaining to the Judicial Service Commission, but we are saying, when is a judge going to take a responsibility? The only thing that he took responsibility is when, on the last minute, on the 90th minute, before the match goes off, he apologizes. But what are the consequences of what you have done?
Yeah. Last question, Prof. Just we ran out of time now. So the last question that I want to put to you is, we saw. So first, I just want you to assure me that because people, in fact, you cut me halfway into my question when I was talking about the supposed ill preparedness.
Yes.
You want to tell us that this is not your attempt to say, oh, we have messed up this case so bad. We can't wait for the judgment day. Let's intervene quickly with this complaint and just so that we throw sand in everything. You like using the word. So that is the first question, so briefly. But the last question also, which you should help me answer very briefly, is there was an article written by Professor Joseph Disho, who is based in Germany, criticizing you. He doesn't differ with you on the principles of your argument about the red line. But he went on to really say what I thought was very disparaging things, saying about you that you like to shine, you went into this matter alone so that the whole focus is on you. Has Professor Disho ever spoken to you about wanting to join you in this case? It has been on the books for 4 years now, since 2021. Has anyone, whether it's Joseph Disho or anyone else, spoke to you to say, look, Job, we know what you're fighting for. We agree with the principle of what you're fighting for. We are joining you. And you said, no, I don't want you guys.
Because it's not even me at that stage yet. The court ordered that we must cite. We had to advertise. I had to pay money to advertise in the newspapers about the case. We had to, apparently, first the other defendant was saying we must save all those people who are nearby the red line. We had to advertise in various newspapers, including this newspaper, Namibian Sun, for people, whoever it is that is interested. Before the case could not even proceed, it was all over. Look, I'm not going. Professor Disho is 61 or 60 something. He tried to call me in the middle of the night because people are angry with whatever it is that is. I'm not going to waste this important time to dignify him with a response. I mean, he must do those things. I'm trying to correct what that generation of Joseph Disho and others couldn't. I'm very comfortable in my skin. I don't run away from fights. So I wish him the best in Germany. He must continue to watch on TV. And one day when he comes here, and maybe I will have a conversation with him. So I will not necessarily waste this public time to be able to respond to him. He's fine. He must. I wish him all the best. I can only pray for him. And one day maybe he will start farming and he will understand these things. The other aspect that you're asking is that, oh, this is just to throw a spanner in the wheels and things like that. No. Look, clearly everybody who was watching can see, and in fact in our complaint to the Judicial Service Commission, we're just wondering, is there going to be a different judgment? What's going to happen? We are determined with this case. Whatever the judgment would be, that's why we're making a distinction. And I deliberately made a video in front of the Supreme Court to make two distinctions, that there are two remedies available for me. The first remedy is that if I'm not happy with the judgment when it comes, we will obviously study it. You can make a determination. There's a remedy, and that remedy is the Supreme Court. And the Supreme Court won't be heard by one judge who's preventing people from speaking and talking about our parents and talking about politicians. It will be heard by 3 judges at least. So we believe that what is wrong in law. Here we are talking about the conduct. But, you know, Toivo, people, you saw the census result that came in terms of how we're doing as a country in terms of our education. People who are able to be sophisticated to understand these things. So we need to do a lot of education. That's why we appreciate programs such as this to be able to explain. Our people do not have the technical know-how. They are not aware of so they can express those things. I mean, you don't expect Satan to praise Jesus. There are people who just don't like Job. And there are people who, I always say, those people, for the 7 years that they made themselves to be Job's critic, they would have gotten a PhD by now in Job Amupanda affairs. So it's fine. I mean, the people who have gotten cars, they've gotten many opportunities because they are seen as criticizing Job, and it makes, because remember, once we take on something and we be able to deal with a specific person, they sweat all the way from their head to toe. So once we do that, they always find refuge in all these other people to criticize. So it's fine. Let the Namibians be able to debate, but we're saying there are two remedies. If we are not happy with the judgment, then we can go to the Supreme Court. If the judgment is in our favor and other people are not happy, they can go to the Supreme Court. But the remedy that is not available is that you can go to the Supreme Court and say, the judge prevented me from arguing. He conducted himself like this. He apologized and did that. The Supreme Court will say that if you are concerned about the conduct of a judge, we don't deal with the conduct of a judge. We deal with the law and judgment. If you are concerned about the conduct of a judge, why didn't you go to the Judicial Service Commission? The same people who are saying we are, just because we are apparently ill-prepared. Look, we were willing to proceed. If Schlettwein would have taken a stand, if all those guys would have taken the stand, because remember, we have a litigation strategy, and only us that know the litigation strategy in terms of our preparation. We have put it to court that no one can tell us the law that created that. We challenged them. Nobody could. And how are we in that position to do that? Even the judge, when he saw that the challenge is there, a serious challenge of law, he went to say, exhume the body and find the article. So the story about us not being prepared it's a misnomer. And because you just presented your evidence, and immediately after you presented your evidence, they didn't even bring a single witness. So we were to cross-examine those people and to ask them questions, but they don't want to go get there. But this is what we see happening. The high tree always catches most wind. In Etosha, a lion doesn't lose its sleep because of the opinion of a springbok, because the springbok is the food of a lion.
Absolutely.
So we accept that, but we are very serious with that. We appreciate really Namibians, and we know they are going to come for me. And they have already been doing that. They're trying to get the furnitures of my kids now. And Namibians have been contributing. And so thank you very much, people of Namibia, for supporting. And we encourage you to continue doing the same. It's not my case. Only is a case of all of us. And I know that some of you would have also done the same. So we will continue. And whoever it is that is coming for me, know that you are not coming after a plastic bag or a plastic politician. So you must be very prepared. You must be fit for purpose.
Yeah.
Shashi, yeah.
Thank you very much.
Okay, thanks.
I appreciate your time, man.
Okay, man.
Yeah. That is Professor Job Amupanda. He's a social justice activist who is fighting for the removal of the veterinary cordon fence, and also having lodged a complaint against Judge Shafimana Ueitele, who is presiding over that matter, over potential conflict of